Hey there, quick question. What do Tom Brady, LeBron James, and The Ohio State University all have in common? They've recently made trademarks a whole lot of fun. Stay tuned. Hey there, Pete Sokol here. I'm the screen lawyer. You know, I'm a huge sports fan. Always have been. Grew up in St. Louis here with the Cardinals and the Blues, Stanley Cup winning Blues. And I'm a passionate Billiken basketball fan as well, if you know St. Louis University. But most of the time I think of sports as sort of a diversion. They're that thing I do when I get home or on the weekends or I read the paper. It's the way I spend my brain power elsewhere, not in my work life. However, recently the sports world has given the screen lawyer a gift. It's given 3 very interesting and kind of humorous trademark applications that help demonstrate what trademarks are and what they are not. Quick starting point. First, trademarks are a source identifier. That is their purpose. They exist to tell the consuming public of a particular set of goods or services that if you see those products offered under a particular trademark, you know that those products came from a common source. That's its whole purpose, to prevent confusion in the marketplace. So people don't wonder where those products came from. They know they came from a consistent source. They'll have a certain quality, etc., etc. A McDonald's burger is the same anywhere in the world because the brand tells you it came from that same source. So with that as the background, let's turn to the sports world. And there's 3 applications, each tell us a little something different about how trademarks works. First, Tom Brady. Very famous NFL quarterback, soon to be Hall of Famer, Boston bred. If you're a St. Louis sports fan, maybe not your favorite guy, but that's besides the point for here. He recently filed a trademark application to be the owner of the trademark Tom Terrific, presumably for sports personalities. However, the trademark office, in its wisdom, refused his application recently because you know what? There's already a Tom Terrific. That's Tom Seaver, world famous Hall of Fame pitcher for the New York Mets, somebody I idolized growing up even as a Cardinals fan. And Tom Terrific is Tom Seaver, and it teaches an important lesson in trademarks. One, yes, you have to use it, and maybe there are people in Boston who refer to Tom Brady as Tom Terrific, but somebody got there first. And if you're the trademark owner, if you get there first and that word or that mark associates you or your company with a particular set of services, in this case sports personality services perhaps, then you own it and somebody later on can't use it. So the trademark office correctly ruled, in my opinion, that Tom Terrific is Tom Seaver, and no matter how much you like Tom Brady, he can't own that trademark. Moving into the basketball world, LeBron James. Again, world famous NBA superstar and budding super businessman now that he's out in LA. He recently filed a trademark application for Taco Tuesday in a variety of social media categories. Now, Taco Tuesday, seriously? But maybe I don't really follow LeBron on social media, but perhaps he uses that all the time and he's going to build some sort of empire around Taco Tuesday. But here's an important distinction. First of all, there's lots of Taco Tuesdays out there, so that might be an issue for him. But more importantly, this teaches a lesson about a nuance of trademark law that governs what type of application someone can file. If you've been using the trademark in commerce already, you file under what's called status of 1A. That means you are already using the trademark. You say, I started using it on this date. You provide samples of evidence to show that you've been using it in commerce, and you can get the trademark, assuming that you pass muster under the Patent Trademark Office. But if you're not using it yet, but you have plans to do so, you want to launch a brand in the future and you want to preserve the name, you can file an application under a category called 1B. You have an intent to use it in the future. Perfectly appropriate, happens all the time. And that's what Lebron did. He intends to use it in the future in these social media services. However, there's an important thing that happens in that. You make a statement under oath that you have a bona fide intent to use that mark right at the date of filing for those goods and services. Again, not a big deal. It seems like just a statement that you make. However, in one of the first news stories about this trademark application, an ESPN story quoted LeBron's business people saying, "We have no specific plans to use it right now. We just want to look for our opportunities." Oops. That very well may have made that statement under oath untrue. And you know what? If you make an untrue statement under oath in your trademark application, you don't get your trademark. So we'll have to watch and see how that turns out. That might just be a lesson to make sure your people who are talking to the press understand what you've just said under oath. Lastly, we come to the Ohio State University. Now again, if you follow college athletics at all, you're probably aware that for the last 15 years or so, Ohio State University has really emphasized the word "the" in front of its name. The Ohio State University, etc., etc. Well, whether you like that or not, it's kind of humorous, I suppose, but recently it filed a trademark application to own the word "the" by itself, or "the," depending on how you want to pronounce it, but not with any other part of the name. So they just want to own the word "the," and the categories they filed under are sportswear, apparel, t-shirts, caps, etc. Well, here's we go back to that conversation about trademarks being a source identifier. In order for them to be granted the trademark for the word the Trademark Office, and I guess the rest of the world, would have to conclude that every time someone sees the word "the" on a t-shirt or anything, oh, I know, that's the source, that's the Ohio State University. Ohio State University, perhaps "the" has been used in connection with Ohio State University for universities, for educational services, perhaps even for college athletics, but not for sportswear. So again, trademarks identify a source. If you own the word "the," that means nobody else can put the word "the" as a category of sportswear. I just don't think that's going to fly. But trademarks are funny. We'll see what happens. Mostly, I just want to say thanks to one of my favorite worlds, the sports world, for making my other favorite world, trademarks, kind of fun right now. Take care. Talk soon.